Weren't we on, it's gone, yeah, weren't we on like 8 something?
8.4.
Yeah.
So we finished due diligence financing and earnest money increase.
I just put it in there.
So 8.4 is where after the due diligence periods, you can increase the earnest money amount. That's kind of nice. So I'm in a situation right now where we have this offer, and the buyer, because they had like some sort of they wanted to get an FHA loan, which requires the fact that you can't get another owner-occupied FHA unless it's been 3 years. So their 3 years is June 15th, so they actually can't even apply for it. You can go under contract, but you can't apply for the loan until the 15th.
That's good to know.
So what they did is they wrote us a compelling offer, and what they said is, okay, after our due diligence and inspection periods, we'll actually also do an appraisal early, so you can get the appraisal done, make sure all that's good and we're qualified, and then what we'll do is we're going to increase our earnest money from $2,000 to $8,000. So on 8.4 they put $6,000 additional dollars, and then we wrote an addendum which says that the earnest money of $8,000 will be released to the seller on April 15th of this year. So what that means is that not only is it's non-refundable as of April 3rd, but as of the 15th, that literally they write them a check saying, here's $8,000.
Which is great, because then she now has money to make her house payments. And
Yeah, so this one, it's a divorce. Her worry was like, well, I'm going to take 2 extra months. I can't stay in this house. And so they're like, well, to help with that, we're going to release the money to you. You'll have $8,000, and she's pretty much going to take that, pay her mortgage. And then it bought them the time to get the house they wanted, and then as of on June 15th, literally they'll already have pretty much the appraisal done, but they'll officially apply for the loan, and then close on July 2nd. Or July 3rd. That was the date. So you can do interesting things and incentives to get deals done with the additional earnest money.
So that's non-refundable, right?
Yeah.
$1,000.
So there's a difference between being non-refundable and being released.
Right.
So when you release funds, it's although it's technically going towards your purchase, you're giving it to the seller prior to closing. Okay.
Got it.
Can we start reading?
All right. So we're on 9 addenda.
Niner. Addenda. There are or are not addenda to the Rep C containing additional terms. If there are, the terms of the following addenda are incorporated into the Rep C by the reference addendum number, seller financing addendum, FHA loan addendum, or other specify.
Yeah.
Very simple.
An interesting thing is that the FHA addendum actually has a number that you can assign it. So even though you say FHA addendum, you still have to give it a number. So you could say FHA's addendum number 1, and then you would say addendum number, let's say you had some sort of other clause, you do addendum number 2 is included as well. So these are with the original offer. That's why these are notated. Because remember, before, you have to have an original offer accepted, and then everything after that is like addendums to the offer. Everything included in it, anything, we discussed it, anything that you change is considered a counter to all offers, right? And so we'll just counter all.
So if you have 2 addendums, you just mark addendum number, and then you put 1 and 2 in there?
Yeah.
Okay. And you don't have to specify other here, you don't have to put the title of it?
If you want to.
If
you
there
don't have
was, if it's something special, I can't even think of something special. I usually have just put like addendum 1, 2.
to. Like personal property list, or, something like that. You don't have to. They always provide an other, just in case, right?
Well, because I remember with Benjamin, we submitted the second offer with 2 addendums, and then one was the FHA one, and the other one was all of these conditions. So I
So that would have been
remember
like
struggling
addendum 1
here.
and FHA addendum.
Hmm? So I remember struggling here, because I did mark addendum 1, and I put 1, and then I put FHA, and then I didn't know if I should put the title in other for the second one.
No, you don't have to.
Yeah.
Okay.
You just have to refer to the number of it, and then it's
Okay.
all taken care of. But you have to refer to them in the Rep C.
Otherwise,
Otherwise,
they'll think they've been done after this.
yeah, otherwise there'll be addendums to the Rep C, not counter, or there'll be counter offers, I guess. Or, hold on, did I say that right?
Yeah.
The original Rep C would be your offer.
I actually had
No.
someone, they had, basically, we had done a counter with them, but they or we made an offer and they signed our offer, and then just like accepted it. And then on the addendum, they did a counter. It was kind of unusual, so I mean, we could have just gone with the Rep C as it was, and that was purposeful because we were in a multiple bid war. So they wanted our offer, but I think it was just like a name change or something
Yeah.
for what they countered on the addendum. So they, in that case, they did both, they accepted. But they
Good.
countered because it wasn't necessarily a condition with the addendum.
All right, so all you really need to know here is that you have to, if there are addendums included with your original offer, you need to reference them in section 9. After that, they're not referenced in section 9. Like, that section doesn't change once it's signed by both parties. All right, section 10, home warranty plan as a condition of the property, as is condition of the property. Okay. Jill, you want to read that?
Sure do.
Thanks for the enthusiasm.
A one-year home warranty plan will or will not be included in this transaction. If included, the home warranty plan shall be ordered by either the buyer or seller and shall be issued by a company selected by the buyer or seller. The cost of the home warranty plan shall not exceed X number of dollars and shall be paid for at settlement by either the buyer or the seller.
Okay, I think it's self-explanatory. This is probably one of the most used sections. Is it typical for the home warranty to be paid by the seller?
Usually.
Yeah,
Yeah,
Sound
pretty
right?
much, pretty much.
that's how we do it.
Yep, so we say, and is it typical to ask for home warranty?
Mhm.
Yeah, it's more typical. Yeah, now if it's a super expensive house, they may not order home warranties.
What about if it's a house that you know is in need of repair? I guess.
One more reason to get it.
You still get it, you still ask for it?
Sure.
Okay.
But you have to realize, like, pre-existing conditions aren't covered in home warranties, so it depends, like,
Right.
if your oven's already broke, if the AC's already broke, if the HVAC's
It's
already
not gonna
broke, like,
cover
all the
all
things
that.
that a home warranty covers wouldn't apply, because everything that it covers is, like, broke.
But you still ask for it then?
I'd probably just ask for the money, instead of, just,
Offer a low price.
like, if it's gonna be a $500 home warranty, just say, replace the water heater for me, thank you.
That's water heater.
Those darn things.
I always ask, it can't hurt, right?
Yeah.
Okay, so usually you would put the home warranty will be included, it'll be ordered by the buyer and selected by the buyer's company, so the buyer's choosing it and basically the seller will pay for it. That's usually how it's filled out, but it doesn't have to be. All right, section 10.2, Gabby's not here, so Carol.
Condition of the property / buyer acknowledgements. Buyer acknowledges and agrees that in reference to the physical condition of the property, A, buyers purchase the property in its as-is condition without expressed or implied warranties of any kind. B, buyer shall have, during buyer's due diligence, as referenced in section 8.1, an opportunity to completely inspect and evaluate the condition of the property. And C, if based on the buyer's due diligence, buyer elects to proceed with the purchase of the property, is relying wholly on buyer's own judgment and that of any contractor or inspector engaged by buyer to review, evaluate, and inspect the property. The provision of section 10.2 shall survive closing.
Okay, let's read 10.3, because they kind of go hand in glove here. Back to you, Chris.
Condition of property seller acknowledgements. Seller acknowledges and agrees that in reference to the physical condition of the property, seller agrees to disclose in writing to buyer defects in the property known to seller that materially affect the value of the property that cannot be discovered by a reasonable inspection by an ordinary prudent buyer. B, carefully review, complete, and provide the buyer a written seller property condition disclosure as stand in section 7A through C. Deliver the property to buyer in substantially the same general condition as it was on the date of acceptance as defined in section 23. Ordinary wear and tear expected. Delivery to property to buyer in broom clean condition and free of debris and personal belongings, and repair and seller or tenants moving related damage to the property as seller expense. The provision of the section 10.3 shall survive closing.
Okay. All right, so I've had a seller who says, I want them to know that I'm selling it as is. Like, I'm not gonna do anything.
Isaac.
So what does this clause say?
As is.
It is, as is. All property sales are as is. There's nothing that they have to do. So basically, what the contract says is that the day we go under contract, whatever condition the house is in, that's what you're buying. Okay, so that's, like you walk through it and you write an offer that day, like I say, if there's a hole in the wall, when they move out, there can still be that same hole. They're under no obligation to fix it. But if they knock a hole in the wall while you're under contract, they are obligated to repair that hole.
Yeah.
So it's in the same condition, not worse. Now, if they voluntarily fix those things, obviously that's not required, but it's just nice. So what they're saying to the buyer is that it's like buyer beware. Like, look, you're buying this as is, so get your inspections done, trust your contractors, but whatever you discover after the fact, whoops, that's your bad. You know? So, and then on the seller side, the seller is supposed to reveal to the buyer any known defects that aren't readily visible.
What should you talk about in the
So did I mention?
disclosure?
Did I mention my friend Shannon and Chris? They bought a house down Bannock, right on the curve there
Oh, that
near
one.
the house.
Yeah.
They've been remodeling it.
Oh, yeah.
Rats.
They've been
Someone.
renovating it
Yeah.
for a year because of rats. Remember I told you the rat story?
Oh, Shannon.
Well, she swears that they probably knew there was a rat problem, but never mentioned it. Although they did have traps. But the reason she hasn't pushed it is because she can't prove that they knew the extent of the damage.
Sure.
Where literally, like
Can you
in
just-
Ratatouille, the rats were like
They had
in
a
the
home
house.
bakery in the home. Did you mention that?
The what?
Oh.
It was a bakery in the house. Like they
Oh, it's even worse. Like
they
it
funded.
rats?
all the
They had
rats.
like a full like oven where they made bread in the house as like a home business. And then that
Obviously
probably added to it why
a
there
health
were so many
department.
rats.
Oh, that's
If
horrible.
it wasn't
having a
They would just leave everything on the ground and wonder why it was missing the next day. It's like
If it wasn't health department approved, that's illegal. And if it was health department approved, they would have been doing checks.
yeah, yeah.
You
Well,
can't bake out your own.
you know how people.
So,
my
my point is,
you
if
have
they
to
had
get a
rats-
license and you have to have an
Right.
So David doesn't-
inspector.
Exactly,
Information.
but an inspector would have caught that. So you
One
could,
would hope.
you could see if they have an inspection.
Bribery under the table.
So,
She's probably got
let's
60,
say-
50 years out of her home.
Let's say in your you give out your buyer due diligence checklist, and your buyer elects to no due diligence. Like, I just trust them. They seem like great people. I trust them. And then they find out that their kid is having allergies, and they find out that it's mold. And then they do a mold test, and they find out that there's extensive mold somewhere in the walls. And they're like going to the sellers, well, you should have told us about this mold. And they didn't have allergies to it, and they didn't really think much of it. So sometimes some sellers may not know of it, and some sellers may know of it but never thought it was an issue. But there is a section for that on the seller property conditions disclosures. They go through those major things. So if the sellers knew about it but clicked none, then it's the seller's bad, and the seller could be liable if the buyer wants to take them to court after the purchase.
But it's
Because
still even
these
better.
things,
How do we prove that?
like it
Yeah.
says, these things survive closing. So if something was not disclosed, and it is, technically you're not buying it as is anymore. It was a known issue. They didn't reveal it, and now you can go to court over
Maybe
it.
they found like a receipt that they left in the house for the mold rehab they did.
Yeah, exactly, something like that. Like
Yeah.
if you remediate
Going
from
in the attic
mold.
and found something.
So here's the case in
Or
point,
maybe
just to
like
cut
a
this
previous
short, which
contractor
is
will contact them.
for buyers, do your due diligence. For sellers, disclose. Disclose, like we say, even if you had a flood in your basement, even if you fixed it all, just say, hey, in 1970 we had a flood, and 40 years ago we fixed this. Great. Just that's how it is. Like, yeah, we had mold in this wall because a pipe leaked and we didn't know it, and so it built up mold. We ripped it out. We fixed it.
I had a client disclose that she had had termites 10 years prior. And then the buyer wanted receipts of how it had been fixed. And she's like, that was 10 years ago. I don't have any of that.
I know.
Yeah.
Well, it's just
that should show up in the
it's all about relieving yourself of the burden of being sued later.
Yeah.
And for the buyer, it gives them the security to know what they are paying for, because once it's closed, you've bought it, and so if you find out afterwards that there was a drip underneath the sink, you're the one that's gonna have to pay the handyman, not the seller. Okay.
It's
So-
hard when they disclose that inspection found there's a leak. Then they said they fixed the leak. They had proof that there was a receipt that the plumber fixed the leak. And then when they move in, it's still leaking.
Well, in that case, if it's still leaking, you would have the
I
ability
told
to
them
go back.
I told them to call the plumber
Yeah,
off the
that's what I
receipt
would
to have them,
think.
warranty their work.
Plumber at that point.
Yeah, some things are hard, like we had electrical panel fixed on one, and like I don't know electricity, like, so it's like, yeah, I guess it looks fixed. Who am I to know, right? But so they provided a receipt, and you just kind of had to trust that. The only thing that you could do is that, again, the buyer could have paid the electrician to spend time and show them what they could have done, but it's all more money. So that's, most of due diligence comes down to the buyer's financial ability to inspect. That's the limiting factor. That's why they just want to hire their buddy that's going to just come and look at the house for free, right? He's a contractor, he knows what to do, you know, and they miss all sorts of things.
They miss
Like
a lot.
rats.
They're not contractors of any sort whatsoever. They just gotta walk through. I had that problem in my first house.
So-
They didn't catch a leak in the water heater.
Oh, wow.
And it was on the back of the water heater, and it was a brand new water heater. They just did it correctly. So it sat in our house for a year. I lived there. Everything was fine. And one day I walked in the back and stepped through the floor.
Oh.
And I was like, what the heck? So I had to rebuild the whole subfloor of the house and redo the whole water heater. I got a picture of me standing in it.
Yeah, of course you do.
There you go. So,
Wait, so David, so if the buyer were to spend all this money in doing all these inspections, and then for some reason the seller decides not to sell, what happens to all that money?
He's supposed to get
It's-
recompensated with the earnest money, so if he'd put $2,000 earnest money.
no, well,
But then the buyer,
Like
the
the-
seller cancels.
yeah, are you saying the seller's canceling or the seller's just unwilling to fix?
No, canceling.
Okay, the seller can't cancel, but if they do, then they owe the buyer the
Just their
the
money.
equivalent of the earnest money. So not only do they have to return the earnest money, or the earnest money is returned to the buyer, then the seller has to pay that amount to the buyer.
So if they had $2,000 down, then
Okay, perfect.
the seller would owe him $2,000.
It's a lot riskier for a
Oh,
seller
I
to
thought it was
cancel, by the way.
equal,
Oh, yeah.
like double amount, no, it's not double.
No.
Well, they get their
No,
original
theirs
money
money.
back, and then on top of that, they get
The same amount,
the
right?
same amount.
So it's kind of double.
No,
Well,
it's
but
not.
they're just getting their
Bec-
money back.
Because
Right.
the first money is not money, it's not
Yeah,
the
yeah,
seller's money
yeah,
yet.
that's true.
So they're not paying out of
So
their
if they put,
pocket.
but if they put $2,000 down, then they get,
$2,000 compensation.
Yeah,
and
exactly.
their earnest money.
Yes.
Mhm.
Okay, but
Well-
if they backed out, if the buyers were to back, they lose all that money that they have.
Depends on where in the contract they backed out.
The reason.
But yeah,
um,
they would lose their earnest money.
Often if a seller cancels, there's a lot more loss to a buyer than to a seller typically. Because if the buyers, let's say, paid for an appraisal, paid $600 for a home inspection, they've already given notice, and like it's a week before, they've already spent all this time moving, and now the seller cancels. The buyer's gonna have a real difficult time. Like, let's say they're now gonna be forced to move, and then they have to find some other place to live temporarily, and the moving costs. So real quickly, their damages could be much greater than the earnest money.
Right.
And so in those situations, the buyer should sue the seller for compensation. In most cases, they will.
Well,
Yeah, because they're out thousands of dollars typically.
Right. Right, because those inspections are not cheap, especially if you do the rate and the math.
And so let's say the same thing happens to the seller, where the day before they've moved out, they've made arrangements. Let's say in fact
They're supposed to be buying a house.
they've already moved into a new house early that they're supposed to buy, depending on the close of their house, and now it all falls through. Yeah, their damages are can be much higher, and they can sue the buyer. So we'll get to that
That's why we have
section
that
where it gives you
clause.
the options, whether you're going to sue or mediate. That's what that comes down to. Okay? So final pre-settlement walkthrough inspection, section 11.
No earlier than 7 calendar days prior to settlement and upon reasonable notice at a reasonable time, buyer may conduct a final pre-settlement walkthrough inspection of the property to determine only that the property is as represented, meaning that the items referenced in sections 1.1, 1.2, and 8.1, the items are respectively present, repaired, or corrected as agreed. The failure to conduct a walkthrough inspection or to claim that an item is not represented shall not constitute a waiver by buyer of the right to receive, on the date of possession, the items as represented.
Okay. Okay, so you can do the walkthrough how early?
7 days.
Up to 7 days. Now,
Some of my new builds, I've done it earlier.
yeah, new build construction is a little different, and plus it's going to be a different contract.
Yeah.
Usually what they do is, we just did one this last week, and from the day of that walkthrough inspection with the contractor, or the foreman and the realtor, they had 7, on this one, they had 7 days that they had to close within, which is this Friday. Or other ones say 10 days, within 10 days of that you have to close, or you get fined $100 a day
Yeah.
if you're not using their preferred lender, right? That's how they do that.
That's true.
Okay, but this one is as represented. Remember, that's as on the day that you own under contract, and whatever thing that you've already negotiated, then you can walk through. The one, you know what the challenge is, just the practical challenge, is they haven't moved out yet.
Makes it
Right.
hard.
Well,
Like-
and they're probably in the midst of
Yeah.
packing.
So as a seller, as a buyer, you wanna go through it, you wanna see the house like, but it's,
It's gonna be with all the holes in the wall when you take the pictures off.
yeah, so when we walked through a house, we were doing our inspection, and when we put an offer in, the house had furniture. When we did our inspection, the house did not have furniture, and then we found out in the office, one of the cabinets had stained the floor where it was, because it covered a large area, and literally there was like two very distinct colors of carpet. And so then we asked them to repair or replace the carpet, and they ended up replacing it. But those are things that we couldn't see. So that's the challenge, is that if the sellers are moving out like on the day you're signing, it's, you know,
Tight.
or you walk through and it's a mess, or let's say
Yeah, 'cause they're supposed to leave
moving
it
crew punches a hole in their wall, and let's say no fault to the sellers have left, they hire a crew, and that crew punches a hole in the wall, drops the piano, you know, whatever they do, that's gonna be the seller's responsibility to fix.
Mhm.
So all you gotta do is take a picture, say, I appreciate you repairing this, like, dent in the wall.
Please remove the piano from the staircase.
Yeah, piano has, you know, piano has dropped.
What's typical with holes in the wall left from decor? It's like my house is an art gallery, so like what's typical? Do they usually ask for it to be filled?
Yes.
Yes?
Yeah, typically you fill them up and do stuff, but like big holes and stuff like that, obviously you have to fix and patch. But
Just wondering like.
Depends how
holes-
picky the buyer
something
is.
that goes
yeah,
in
it
the
really
wall.
does. It depends how big the buyer is.
Okay. I would
Some people just think, oh, that's just normal. Other people leave huge holes because that was where the TV thing was.
Yeah, remember in
TV is
the,
actually real property.
And it's
in
supposed
the
to
offer,
leave
in the
it.
offer, the brackets
Correct,
are supposed to be left.
which is stupid.
So you wanna make sure that if the guy has his TV or whatever that they love, that the brackets are excluded.
Right.
But it brings up a point that, what do you do with the holes?
Cover
You
it,
patch
fix
it.
it.
You
Patch
should,
them up,
you
paint.
should patch them if the brackets are excluded.
Right.
Okay, but that's one of the reasons why they include brackets, because of the damage to the wall. That a lot of people, it's like almost the same cost to buy a new bracket as to fix the wall. You know, it's like $100, so it's
Usually
like.
people put the TV in the same place anyways, so.
Yeah, and if it's meant to
That's
be like there, and
Mm.
unless you're going all out with the 100-inch, you know.
60.
All right. I'm gonna go to my office really quick and
Okay. We'll do sharing.
Should we read?
Oh, it's my.
keep sharing, keep sharing.
Like, why are you VIB?
Whoa.
Changes during transaction. Seller agrees that except as provided in section 12.5 below, from the date of acceptance until the date of closing, the following additional items apply. Alterations, improvements to the property. No substantial alterations or improvements to the property shall be made or undertaken without prior written consent of the buyer. Financial encumbrances, changes to legal title. No further financial encumbrances to the property shall be made, and no changes in the legal title of the property shall be made without the prior written consent of buyer. Property management agreements. No changes to any existing property management agreement shall be made, and no new property management agreements may be entered into without prior written consent of buyer. Long-term lease or rental agreements. No changes to any existing tenant lease or rental agreements shall be made, and no new long-term lease or rental agreements as defined in section 6.1A may be entered into without the prior written consent of buyer. Short-term rental bookings. If the property is made available for short-term rental bookings as defined in section 6.1B, seller may not, after the seller disclosure deadline, continue to accept short-term rental bookings for guest use of the property without the prior written consent of buyer.
It's like
To
the
know
Airbnb.
Yeah.
Authority to signer. Authority to signers. If a buyer or seller is a corporation, partnership, trust, estate, limited liability company, or other entity, the person signing the rep C on its behalf warrants his or her authority to do so in the bond or contract. So that's basically us representing.
And we did learn in that
What
one
did you
class
just
where
say?
if it is a trust,
13.
Oh, we did.
you put the trust name and then
Authority
you
of
put
signers.
how did they word it? The signee or, and then you have to put that person's name too on the contract.
Oh, really?
Did you do
Correct.
this?
So I now have a trust. like the ones where they say that the person, you just, I asked who the seller was, and they say just put the family trust, not the person's name.
And technically, title will actually take care of that for you.
Okay.
If you don't do it correctly, they'll,
Let me know what to do.
yeah.
Okay. So I need to ask, I need to
Because
send
they'll
you
actually
pictures.
need the trust information and find out who the signee is,
Yeah.
who's authorized to sign for the trust, before they transfer, are able to do clear title.
You good?
Seal it up. Do we just read authorize, authority
Authority,
of
Yeah,
authority of
signers?
signers.
On the outside?
Yeah.
Yeah.
Yeah, we talked about, I remember one class we talked about, should you verify that?
Yeah, we had some,
Or should you just trust them?
Verify.
Verify.
Oof.
Never trust you.
Never use the word trust.
So
I would
like,
sign it
if
and
you
then
say,
verify.
okay, you say your name is Sarah.
Like you were talking about.
Yeah, Chris.
Oh, you finally found it?
Chris pulled up the picture. where he
You
found
are
her.
in the floor.
The subfloor.
He's straight up in the floor.
Oh, man.
And are you having fun in there?
It was fun.
Is that the
He
Tennessee
looks like
house?
he's having fun.
Yeah.
I go through my
Tennessee.
floor. It's such a happy day.
it is always nice to have their proper name, but sometimes you'll find out later.
I think
But you don't want to find out at closing that the names on their
Right.
ID doesn't match their.
Right.
Yeah.
I almost did that.
Wait, but who tells you though? Because in this case, I remember Carlos told me of the correct name for my buyer.
Well, usually on the pre-approval letter, I've had
Yeah,
to make changes.
basic
So
terms
Caleb will do the
usually.
pre-approval letter, and then I change the name. and
But, but I'm
to
thinking
match.
if it's a different lender who's not like Carlos or Caleb, like do they still let you know
They
You'll
should-
see the pre-approval
Well, so
letter.
the bank requires that the name on the
contract?
purchase contract, yeah, is the same on the loan. They have to match. So the one nice thing about having a bank involved is that the underwriters make sure that everything's good.
So if they were to catch it, they'll let you know to fix the contract.
Yeah, they would say write an addendum correcting the name. Yep, or like if it's an LLC,
Adding Allison.
yeah, adding the LLC and who's the assigned manager of it, their name. What was it? Remember I think you were in it. It was like, you write the LLC, so like Rise Utah Realty LLC, member David
Manager.
Bustamante. And so that when I sign, I'm not signing Rise Utah
Seymour
Realty, I'm
used to do
signing
like
David
for the
Bustamante.
trustee, so you write the name of the trust, and then the trustee, comma, trustee, and then put the name of the trustee.
Okay,
It's gonna
so,
be signed, 'cause
so
they
all
would know the
these
sign.
little sections are ones that we gloss over because you don't have to fill them in, but they are important. So who's at 14 now?
Oh, I think I'll read that. Complete contract. The rep sheet together with its addenda, any attached exhibits, and seller disclosures, collectively referred to as the rep sheet, constitutes the entire contract between the parties and supersedes and replaces any and all prior negotiations, representations, warranties, understandings, or contracts between the parties, whether verbal or otherwise. The rep sheet cannot be changed except by written agreement of the parties.
Yeah, so this is that.
It needs to be in writing.
Has to be in writing. Doesn't matter what you said due to warranty. If it's not in
Written.
this, it effectively doesn't exist. Now, we're not talking about like morally, you felt like you've been cheated. Like if the person promises you, like that happens all the time, right? Like, I'll give that to you. I'll include that. I'll do this, and then you move in, nothing's there. Like, well, it wasn't in the contract. You could be upset about it, and you could feel misled, and you probably were, but there's nothing legally you can do about it.
We had that during the inspection. My homeowner said, "Oh, you can have that leftover wood flooring that was left over. You can have that." But then when everybody helped her move, they
Took it. They took it.
took it. So when the buyers moved in, they were really upset about it. And I was like, "It's not on the contract," because I didn't know anything about it. So it's not on the contract. Sorry.
Well, and let's say the seller didn't really mean for that to
Yeah, it
happen.
didn't mean for it.
But she's not gonna go out of her way to like go find it
Right.
now that it's missing or thrown
I need
away.
that floor back.
You owe me that $500 in extra flooring that was sitting there, so you're gonna go buy it. No, I'm not.
Stole my wood.
There's that.
Okay,
There's that.
mediation. Okay, so this is when things don't go right.
Okay. Any dispute relating to the rep C arising prior to or after closing shall or may, at the option of the parties, first be submitted to mediation. Mediation is a process in which the parties meet with an impartial person who helps to resolve the dispute informally and confidentially. Mediators cannot impose binding decisions. The parties to the dispute must agree before any settlement is binding. The parties will jointly appoint an acceptable mediator and share equally in the cost of such mediation. If mediation fails, the other procedures and remedies available under the Rep C shall apply. Nothing in this section 15 prohibits any party from seeking emergency legal or equitable relief pending mediation. The provisions of this section 15 shall survive closing.
Okay, so do you have to go to mediation first, or may at the option of the parties? That means that if you don't think mediation is going to work, you can go straight to court, something a little bit more serious.
What do you usually click? Because I've been doing may at the option of the party.
I usually do may, just because then that leaves my clients the option to do whatever they want.
Exactly.
If you put shall, then you have to go to
You're forcing
mediation.
them to.
But that's just what I've been doing.
Yes.
I don't know necessarily the benefit. I totally get what Carol's saying, which is like, as a buyer, it gives your client the options.
Right. So depending on
But
what's happened and what advice their attorney gives them, it leaves them open for options.
Smart.
So if you do the shall, it forces them to do mediation for it.
I've noticed that when you share offers with your clients too, they're like, okay, well, what does the contract say? Like, very few people even go over the mediation section. Well, it says here, if there anything does go wrong, that you have to go to mediation. Well, what's my other option? Well, you may choose to go to mediation if anything happens. What does that mean? What is, and then you got to explain the whole legal scenario to them. But if you're truly representing your clients, you may want to let them know all their options,
Oh, yeah.
including the legal mediation part.
Sure.
Mediation's usually best, assuming people
It's definitely cheaper.
are, it's
Yeah.
cheaper, and it's if we can talk it through, but it's us resolving our problem, coming to a middle ground. But if you know that you have two polar opposites, you know you're gonna have to go to court and have someone else decide your fate.
But I find that many times when we write the contract, we do it here at the office, and then we just send it DocuSign.
Mhm.
And I don't even think they read this.
No, they don't.
You know,
So
She just
and many
kinda
times I
explained.
don't think there's even an opportunity for you to explain any of this.
it's hard.
So-
You know why it's hard is because they're so either they don't understand real estate, and they're too focused on price, like especially as a listing agent. So what do you charge? What do you charge? It's like they don't even get into these kind of things to really understand them. And then you may feel the pressure as well, or they're impatient. You're like, okay, I want you to understand these things. So it's our job to help tell them what they don't know. And they don't know a lot.
I know, so what, you get on the phone before they sign? After you send them the contract?
You can go over things.
Yeah, you review the contract with them. Now, you don't have to like go in detail on everything, but just say, hey, look, there's a couple sections here I just want to go over. It's like even the section there that's not even a selection, but where it says that the seller's going to pay for the homeowner's policy, right? Like, I didn't know I had to pay for that. Like, that's something that they have to pay for,
On the
but
seller's
it's not necessarily negotiable.
Yeah.
Our standard contract requires the seller to pay for the Alta policy.
Yeah. I did have one person, well, can't the buyers pay for that? I'm like, no,
Well, you're the one selling the house, yeah.
you need to guarantee title.
Mhm.
Well, I want to guarantee title. Well, if you don't, then we can write an
Well,
addendum.
let's just up the price $2,000 and.
Right.
That's true.
All right, 16.
Default. Buyer default. If buyer defaults, seller may elect one of the following remedies. A, cancel the Rep C and retain the earnest money deposit or deposits. If applicable, as liquidated damages, maintain the earnest money deposit or deposits. If applicable, and trust and sue buyers to specify and force the Rep C or C return the earnest money deposit or deposits if applicable. Say it both ways. To buyer and pursue any other remedies available at law.
All right, that's what we talked about before. If it's enough, take the earnest money and be done with it. That's what most people will do. But if you've really lost out big time, and that's usually if it's closed late in the game, then you cannot accept the earnest money. Once you accept the earnest money, that's what you need your clients to understand. If they accept the earnest money, they can't sue. You have to release the earnest money and then sue. So again, if you by mistake said, yeah, take the earnest money, then take it into court for the rest. As soon as you accept that earnest money, you've accepted liquidated damages, and you can't do anything more. That's what you need. That's the main point you need to understand.
Okay.
Alexander Dieterman.
Okay, seller 16.2.
Seller default. If seller defaults, buyer may elect one of the following remedies. cancel the REPC, and in addition to the return of the earnest money deposit or deposits, if applicable, buyer may elect to accept from the seller as liquidated damages a sum equal to the earnest money deposit or deposits, if applicable. Maintain the earnest money deposit or deposits, if applicable, in trust and sue seller to specifically enforce the REPC, or accept a return of the earnest money deposit or deposits, if applicable, are you kidding me? And pursue any other remedies available at law. If buyer elects to accept liquidated damages, seller agrees to pay the liquidated damages to the buyer upon demand.
Okay.
I've never said applicable so much.
Applicable,
life.
if applicable.
It's applicable to the situation.
Jeez.
Okay, so what does it say?
If applicable, that's all I got.
If applicable. So if it's applicable that the earnest money is enough, take it.
Yeah.
If it's not,
And you can take them back for more.
then reject it and go for more. But just realize that's gonna take time and
Oh, yeah.
money and.
And risk.
So, let me just say this, realizing that suing takes time and money and most people don't wanna do it, when you're accepting offers as a listing agent, think about earnest money and how important that is for damages.
Yeah.
Like we're accepting contracts that only have $500 earnest money. That means if anything goes wrong, that's all you're gonna get. And we're like, well, we don't have a lot of money. That's why you also may wanna consider the offers like somebody with 20% down versus no money down. Because no money down also doesn't have earnest money either. Like they're like borrowing their earnest money and then they get their earnest money refunded when they close. So, we've typically said half to 1% being more normal. But few people are doing that nowadays, this low money down concept. It's like, I always get like $1,000. $1,000 seems like, you get $1,000 on a condo and you get $1,000 on a $400,000 home. You're like, so if you are a listing agent in the scenarios, ask for more. If you're a buyer's agent, I mean, you can try and ask for less, but if they come back, they understand that, hey, look, this is locking you in, or this is to cover loss in any case you default. So that was one of the concerns actually for my buyer that I started telling you, or my seller that I started telling you about. She's going to get this $8,000, but I had to tell her, I said, hey, look, they're releasing this money to you, but if anything happens, she has an IRS tax lien on her house, and so what's going to happen is that they're closing. She can't order. She has to order the tax lien once she gets. She's going to get the. She gets the contract, and then no more than like 30 days before closing, she has to close like within 30 days of receiving the release. They're getting a divorce. It's kind of complicated. The husband has a sole proprietorship, and the tax lien is against him. But since he's on the house, it went on the house, and it went on her credit too. But from what she's told me from her legal conversations, is that she's going to be able to get it released from the house prior to closing, so that only half of the profit that's due to her will go to her, and then the other half pays off the lien. But the fact is that there's not enough if they split the profit to pay off this tax lien. And so she's betting on the idea that, from what she's been told, that the tax lien will be released. Otherwise, if it's not released, she actually can't close. So it's going to be like $3,000 short. Like she doesn't have enough money, and she doesn't want to close if she's not going to get anything. So here's the problem. We're actually signing a contract, and in that contract they're going to have up to $8,000 of earnest money. And once she accepts that contract, if she cancels, she has to pay them in the beginning $2,000, and then after the 3rd of April, $8,000. And then once it's released to her, she would have to give that all back plus an additional $8,000.
That's 16. Oh.
Yeah. So ouch, huh?
What did she say? Is she okay with that?
She's like, so I said, okay, well, so as a realtor, I'm just like disclosing all of her options, and I'm glad that she's a person that listens. I said, well, what's the likeliness of this happening? You've talked to several people. She said, it's like 90%, not 100, like 90. I'm like, okay, well, at this point, it'd be cheaper for you to close and, close and pay $2,000 than not close.
Yeah.
But it's explaining those options because of this default clause. You have to explain that to the seller, like, well, what happens?
Sorry.
So, like, for example, we were talking earlier with Chris, the one in Spanish Fort. Did they have to pay this? Does the seller have to pay this now?
So basically, the seller is going to pay. They already had the earnest money set up, and they're set up. But at the end of it, he's going to, if he defaults, they extended it out till May 1st. So if he goes past May 1st, he has to pay for their appraisal as well.
So it has to pay the earnest money plus, no, well, the earnest money is released, but then.
Yeah, and that's all gonna go on.
Yeah.
So we extended due diligence, we extended the seller offer.
So the
Some
buyer,
life support stuff.
so the buyer's agent negotiated an additional
Time.
time. Well, he said, well, we'll give you this time, but you're gonna have to pay us, that appraisal fee.
So it's not
So
canceled.
instead of
If-
1,000, now it's
If
up
we
to
get
about
past the May 1st.
1,600 now.
And he agreed.
Still alive.
I
I don't know how, but it
It's
is.
a miracle.
That was
Folks
a,
really want that house.
well, yeah, they do.
All right, 17, attorney fees and cost governing law.
Oh, sorry.
Julie, yes.
It's been a while.
Good morning.
Sorry.
You said?
I'm getting sick, yeah.
Oh, no.
In the event of litigation or binding arbitration arising out of the transaction contemplated by the REPC, the prevailing party shall be entitled to costs and reasonable attorney fees. However, attorney fees shall not be awarded for participation in mediation under Section 15. This contract shall be governed by and construed in accordance with the laws of the state of Utah. The provisions of this Section 17 shall survive closing.
Yeah, so whoever wins doesn't have to pay their, they probably have to pay their fees, but they'll get compensated back.
They have to pay their mediation fees. Right.
Yeah, you pay your
Attorney fees.
mediation, but not attorney fees. Section 18, Gubbi.
Notices, except as provided in section 23, all notices required under the Rep C must be A, in writing, B, signed by the buyer or seller giving notice, and C, received by the buyer or the seller or the respective agent or by the brokerage firm representing the buyer or seller no later than the applicable date referenced in the Rep C.
Yep. So, any notice of cancellation, stuff like that, needs to be in writing. Email is not what they mean. It's like there's a form for that.
Sign.
Yeah.
Form for everything.
I had a guy yesterday who wanted to, he's like, okay, our financing expires today, but there could be some issues, so we want to know if you would extend the financing deadline. Well, it expired yesterday, and when there's no specific time mentioned, it's defaulted to 5 p.m. Guess what time he sent me that email?
501.
5:01.
No way.
He sent me the email asking me if we would consider an extension.
Oh my God.
And then I didn't respond to it immediately. And then he texted me. He's like, "Did you see my email?" And it was like 6 o'clock then. I'm like, "Yeah." I said, "I'm out of the office, but isn't your financing period in today?" He's like, "Yeah." I said, "Well, then you're already out." It's like, "Oh, well, I thought I'd just ask, but I guess we'll be okay." So, well, you're not getting an extension from us. Your money's ours, baby.
You're the evil one right now.
Hey, you gotta do it.
Just hold them
Well,
accountable.
why?
I know,
I do that
I know.
because it ensures the close. Like, once that money goes hard, the likeliness of them canceling, it
Diminishes.
drops dramatically. And if they do cancel, well, my seller's compensated to cover the month we've lost in marketing his property.
It's like Dieterman, they canceled right at the end. He lost his money, or his money went right to him.
Yeah, was that like the day before
It was
signing?
like 2 days before signing.
Yeah.
Oh, I got a job in Florida, I can't do this now. Everything was done. Yeah, we found a
Cancel his
place, yeah, he was buying it.
Oh, gosh.
That was my first one.
I've had one cancel on it was gonna be a rental property that they were buying, and the lender checked that when it went to final underwriting, like the 5 days before, they checked and said, "Oh, this is too high rental ratio. We can't lend the property to you." Well, because they were gonna have their son occupied. They were actually a non-occupant co-borrower, and their son was applying as an owner-occupied. So which made it owner-occupied rules, and therefore they couldn't get their financing. And they didn't check that until it was literally 3 days before closing.
So
They-
that's on the lender, isn't it?
Oh, it's the lender's fault
Yeah.
for checking last minute on something like that.
It's always a lender's fault.
But
I would think you'd still qualify because it's
But
all
in
occupied,
essence,
basically.
between the buyer and the seller, the buyer wasn't able to perform, therefore they lost their earnest money deposit. I think on that one it was like $800. And then guess whose fault it was?
The agent.
My fault, of
It's always
course,
the agent's fault.
because I somehow didn't know those things. But it did highlight in my mind the need to always check and to emphasize that to people,
Call the lender.
so as long as I'm telling, hey, borrower, we're gonna check with the HOA because we need to make sure these ratios are okay before your financing is expired. Hey, lender, the ratios of owner to non-owner on here are a little suspect, so you need a check. So as long as I'm telling people that, even though I'm not the one checking,
Just taking the one off you.
yeah, yeah. So when they didn't know, so it was like, I just assumed people knew, but no one really knew, and then last minute. So he still bought a property, but the lender and I both contributed half
Oh.
to make up for it, just to keep the deal together.
I love that
Sucks.
too.
Yeah, exactly.
You know how to do what you gotta do.
Okay,
My turn.
18, notice, we read 19.
No assignment. The REPC and the rights and obligations of buyer hereunder are personal to buyer. The REPC may not be assigned by buyer without the prior written consent of seller, provided however the transfer of buyer's interest in the REPC to any business entity in which buyer holds a legal interest, including but not limited to a family partnership, family trust, limited liability company, partnership, or corporation, collectively referred to as the permissible transfer, shall not be treated as an assignment by buyer that requires seller's prior written consent. Furthermore, the inclusion of and/or signees or similar language on the duty on the line identifying buyer on the first page of the REPC shall continue seller's written consent only to a permissible transfer. I've seen that too, like agents will go in, put an offer on a property knowing that the market's going up, and before they close, he's trying to sell it to somebody else at a higher price before he's even closed on it. So he basically sells the contract, he's trying to sell the contract to buy the property
Can I do that?
at a higher price.
They can do that, right?
Well,
If they get permission.
yeah. But in most cases, they're not going to give it because the seller would rather benefit from the price increase,
Right.
not the seller. Okay. All right, risk of loss, section 20.1.
As of closing, buyer shall be responsible to obtain casualty, I'm sorry, wrong one. If prior to closing and part of the property is damaged or destroyed by
Oh,
fire.
you're on the right one, 20.1.
Oh, I knew that as an extra read it. I was reading it and then I seen risk of loss
Yeah,
at the
you
bottom. I was like,
switched.
oh wait, I gotta switch to the other one. All right. As a closing buyer shall be responsible to obtain casualty and liability insurance coverage on the property in amounts acceptable to buyer and buyer lender if applicable. You read the next one too.
Yeah.
If prior to closing, any part of the property is damaged or destroyed by fire, vandalism, flood, earthquake, or acts of God, the risk of such loss or damage shall be borne by seller. What's borne mean?
Borne.
Born.
Glasses, folks, glasses. All right. Provided where.
Why are your glasses today?
Old age kicking in. That is the cost of repairing such loss or damage would exceed 10% of the purchase price
You're so
referred
red.
in section 2. That's good
Together,
stuff.
keep it
All right. Either selling or buying may elect to cancel the REPC by providing written notice to the other party, in which instance the earnest money deposit or deposits, if applicable, shall be returned to buyer.
It's always a good time.
It's a good bit screwed by the sound.
So I guess there is a clause here where the seller does have the right to cancel. Basically, if his house gets destroyed,
Right.
like, dude,
God.
I'd love to sell you my house, but like the hurricane, like just wiped it out. So
And I can't afford to fix it in the condition that
So-
it was in before.
Right.
and it's just so if the cost exceeds 10% of the purchase price, then he can cancel. So I guess if the cost only exceeded 5%,
Then he would still have to do it.
then he still has to do it.
Wait, so the earnest money deposit is returned to buyer, but not they don't have to match it anymore.
No, it's just sucks, but you know, God spoke and
The tree
destroyed the
fell on the
house.
house, and the landslide took the house down the mountains.
Yeah, I mean, we don't have too many natural
Go for it.
crazy disasters here, but you know. So what happens, like in states like Florida, because a lot of my network, I spoke with guys like in Florida and North Carolina and stuff when those hurricanes hit, and every single house that was under contract had to be re-inspected,
Yeah,
required by the lender prior to closing.
that makes sense.
So everything was delayed because they're like, yeah, we're not going to lend in this entire area until we verify that the house is in the same condition prior to closing. So, and of course, some houses weren't able to close because they lost, you know, roofs, windows, and too many things.
So when he says he has to be inspected, who does the inspection? The appraiser?
Could be the appraiser for the lender who verifies, or just the buyer no doubt, or the
Oh, yeah,
seller,
right.
or it could be the seller who's saying, yeah, my house is like I'm not able to sell at this point, like because remember, same condition.
Yeah.
So if all your windows are busted out right now,
Yeah.
yeah.
And the insurance company goes under.
All right, time is of the essence, 21.
Time is of the essence regarding the dates set forth in the Rep C. Extensions must be agreed to in writing by all parties. Unless otherwise explicitly stated in the Rep C, performance under each section of the Rep C which references a date shall absolutely be required by 5 p.m. Mountain Time on the stated date. And the term days and calendar days shall mean calendar days and shall be counted beginning on the day following the event which triggers the timing requirement. Example, acceptance. Performance dates and times referenced herein shall not be binding upon title companies, lenders, appraisers, and others not parties to the Rep C, except as otherwise agreed to in writing by such non-party.
Yeah, some people don't understand, like, no, we need to respond, like, there is something called a deadline.
Right.
Like, well, we'll just get an extension, let's do that.
I know, I dealt with somebody like that, it drove me nuts.
Right.
There were like 5 addendums extending the signing time.
Yeah, and sometimes it just puts stress into it
Yeah.
when they don't feel like the urgency of the contract.
Sure.
And sometimes it's just because they can't help it, like, it's in a trust and they have to have 3 people meet who are in different states.
Yeah.
Okay, can we take 5 more minutes, we'll finish this?
Sure.
Yes.
Electronic transmission and counterparts.
The Rep C may be executed in counterpart. Signatures on any of the documents, whether executed physically or by the electronic signature, shall be deemed original signatures and shall have the same legal effect as original signatures.
Yeah, so remember the first Rep C is the offer, and then there's acceptance, and then there's everything else. Oh, Kristen, I think you just locked me out.
I'm not in
Oh.
your,
She's like, "Get out."
Sorry. Okay, no, it was just timed out, sorry. Yeah, so, an interesting note, I think it was the Board of Realtors or them who actually invented DocuSign. Because they're an affiliate of the Board of Realtors, I think it was, I think either they invented it or they purchased it, but I think they own it. Because DocuSign is predominantly used by Realtors.
Acceptance. Acceptance occurs only and when all of the following have occurred. A, seller or buyer have signed the offer or counteroffer were noted to indicate acceptance. And B, seller or buyer or the agent has communicated to the other party or to the other party's agent that the offer or counteroffer has been signed as required.
All the signatures in the right places.
And you have to communicate it.
Yeah, so you have to get all the signatures and you have to tell them that it's been communicated. Okay, so
Signed,
here's,
delivered, like sent and
That's why you always want to
communicated,
say received, thank you.
yeah, so let's give an example. Let's say you submit an offer, $5,000 under, they're gonna accept it, they sign it, and then after they sign it, they haven't given it back to you. Oh, no, I guess that would be in their benefit. Let me think of something. So the seller,
Gets a better offer before they've received. So say like,
Oh, so-
verbally said that they're gonna accept it, but then all of a sudden I get another offer.
yeah, so I've actually had that happen when I was a listing agent. We
Like
said,
you would send it
I
back.
think we're gonna accept your offer, and I just said, based off this, and then we got another offer higher. And then I said, we're not accepting your offer. Well, you told us you're gonna accept it. Like, she was like yelling like it was,
Breach of
I
contract.
said, this is not a breach, yeah, it's not a breach of contract, we haven't signed anything. Well, you said it. Well, we got a higher offer. That's,
At the time we meant it.
You know what's the problem, I think, is when you're like a limited agent and when your seller signs the contract and accepts it, you by being the limited agent, you're already receiving it, right? So if another offer comes, you
okay,
can't.
yeah, that'd be a
contemplate
difficulty
it.
of a limited agent. Well, yeah, let's think of an example where the seller gives you a counter offer and you signed it, but you haven't,
Sent it.
let's say you're going back and forth and you signed it, but you haven't given confirmation. Well, let's say the agent waits the night, but overnight,
Receive another
the
offer.
seller receives another offer,
Better.
and accepts that offer. And before they receive your confirmation of acceptance, they send you a cancellation notice of the counter. They can cancel the counter before it expires, so they don't have to wait till the expiration date. They can cancel it.
Mhm.
So they cancel it, and then
They want it. And then
they
you
accept that offer, and you're saying, we signed it.
But
It's
you
not
didn't
just,
give it to me.
acceptance is not signing, but it's receiving it back.
Mhm.
You see how important that is, and how in a rush scenario you could get in trouble if you not only have to sign it, you have to send it. And that's why so whenever you send over offers, I call them and I say, hey, the offer's coming. I want to explain the offer to you. I text them, please receipt. I email them, please email me receipt of offer. And so that's receipt, but what we're talking about is actually the acceptance part. So, but I just get into the habit of communicating with the agent so that on both sides, I'm saying, I got it, I'm going to get it to you. Did you get it? Did you get it? Because I want to make sure if I've given them something or if they've signed it that we have acceptance.
And if they don't reply to your text saying that you get it, but you sent it through email?
I had one mistake where I wrote an offer and everything, and I didn't text them telling them that we had sent over the offer. I didn't call them. I just thought they would just get it, right?
Right.
And then they got, 2 hours later, they got other offers and they accepted the other offers. I'm like, well, why didn't you at least tell me? Well, your offer was just lower, so we just went with the highest offer. Well, at the time, I didn't know there was other offers.
Makes sense.
So, but they were like ready to sign it, so maybe if I had called them, maybe,
Usually you would have given them 24 hours, so it probably wouldn't have been anything you could have controlled anyways.
All right, contract deadlines.
Date.
So deadlines are just, these are the primary things we discuss. Make sure on seller deadlines, seller disclosures that this, typically as a listing agent, you want probably a week, because part of the disclosure is getting like HOA docs and everything out to them. So if you haven't already ordered them, preliminary title, all those things, it takes about a week, so 3 days is typically not enough. Due diligence on a purchase price is probably $400,000 and under, 2 weeks is fine. When you get into higher purchase price ranges, they typically will do more due diligence, so it could be longer. Financing is typically 3 weeks on most lenders, especially if they're already pre-approved. Don't accept offers that don't have pre-approvals, just as,
Save yourself the drama.
yeah, if you're a listing agent, you increase the chances of it getting rejected. And also realize that jumbo loans are loans above conventional limits, so like 500,000-ish,
What's
take
the jumbo
usually,
loan amount now?
oh, I don't know, like 486 or something like that. I think,
I thought,
I don't know exactly.
Wait, is
That's
that,
why I have a
what
preferred
does
lender.
that mean? Does that mean that that's the
Yeah,
most that people can borrow?
it's in the high.
jumbo loan is just a
So-
certain amount, like anything over $500,000 is considered a jumbo.
It's just like means
It's just
state.
a straight amount, straight amount.
It's not Dumbo. It's
That's
jumbo.
loan amount, right? Not
Yeah.
purchase price.
Yeah.
Right.
Could be wrong.
So for those
So just
just
realize
takes
that,
up a million
just
pounds
realize
more
that if
home,
you
it
are
takes
putting an
longer.
offer on a larger home, like if you get a $700,000 home
Right.
and you're getting a jumbo loan, it takes longer to close on a jumbo.
Right.
So give them, instead of 3 weeks, give them 4 weeks financing.
Okay.
Okay, so offer and acceptance. What's a good response time that we should give people?
I mean, at least 24 hours.
Well, I have learned
Ask
that you
them.
ask.
Yeah.
Ask them.
Yeah.
Say, hey, I'm going to be submitting over an offer to you. This is communication with the agent. So how fast do you think you can get back to me? Now, sometimes if you don't ask, because you know it's a pressure cooker, you can write it, but if they can't respond,
Then here's right there for nothing.
A lot of times too, I'll try and do it before the weekend, before they do any open houses or people get lucky loose, because then that's when they share more offers. So I'm like, you have to respond before 5 o'clock on Friday.
some listing agents don't like to work on Saturday nights and Sundays. So they say, hey, write all offers to this address, and if you're writing it on a weekend, give us till Monday at 7 o'clock to respond to you.
Sure.
Yeah, I've seen that.
So it's your bad if you don't see that.
Yeah.
Because they won't respond to it. Why haven't you responded to my offer Sunday afternoon? Why haven't you responded Monday morning? Why haven't you responded?
Well, I already
Yeah.
told you, look at the read the listing.
All right, and so you sign and date. In DocuSign, you'll have the dates here. If you don't put a time, then it's assumed 5 p.m. Offer and acceptance, and just, again, they can accept, counter, or reject it, and then they sign. That constitutes the packet, boys and girls.
We made it. Yes. A week's worth of stuff.
Aplauso para todos.